All right, my friends. I just pressed the Let's Go Live button, which means we got to wait for the stream to fire up all across the fruited plain of the interwebs before we go ahead and get started. Got to make sure those tubes are working because we got some business to attend to today. It looks like we're live on YouTube. Hello to locals, our friends on Rumble, our membos on Telegram. It looks like we're alive and well. That means we can go ahead and get started. So let's do it, shall we? Hello, my friends, and welcome back to yet another episode of Watching the Watchers Live, the show that spotlights misconduct involving police, prosecutors, and politicians. My name is Robert Gouveia. I am a criminal defense attorney, and today we are talking about Trump trials. We got 3 cases that we are peering in on today, starting off in Florida. Donald Trump was there in Judge Cannon's courtroom today. 2 motions were being argued, and we've covered them at length. Very good, very interesting motions, and we've talked about them both. One was that the entire indictment should be dismissed, or at least the first 32 counts, which covered all the documents, should be dismissed for vagueness because the charges that Jack Smith brought against the former president are vague. Nobody knows what he got charged with, and so how can you be prosecuted for a crime when you don't even know what the charge is and you can't defend against it? Kind of difficult thing to do. So Cannon heard oral arguments and, my goodness, right away denied it. So we just finished oral arguments like an hour or 2 ago, and then she responded and denied that motion. So we'll go through that one quickly and see what is inside the denial. But I think a lot of people were predicting that that was normal. Remember, this was just one of maybe 6 or 7 different motions. There was a bunch of them that got filed simultaneously. And the other one that they were arguing about today was the Presidential Records Act. And this one we have not gotten a ruling on yet, but we're wondering if she grants the motion to dismiss on this or uses this or the arguments that came out from today's oral arguments at the evidentiary hearing to determine that this implicates the selective and the vindictive prosecution motion that Trump's team has also filed. In other words, Jack Smith and his team are misinterpreting intentionally the Presidential Records Act because they are selective and vindictive prosecutors, right? So there's a lot of overlap between the two. If we're talking in Kamala speak, just think about multiple Venn diagrams overlapping each other, happening all over the place right here, in this case, Kamala Harris. So we'll see what's inside these motions and what happened in court today, because Trump was there. He was there in person. The crowd was there welcoming him in big numbers. We also had some updates on how things went inside the courtroom. And by some attorneys' accounts, especially some on Trump's team or formerly on Trump's team, guys like Tim Parlatore, they say that the Florida case is their biggest case. They're the one that they're most concerned about. And so we'll talk about what happened in there. And Trump is also commenting. He was on with Greg Kelly yesterday and had a conversation with him about the classified documents that he had versus the documents that Joe Biden had that he did not get charged for, but Joe Biden's DOJ is charging his top political opponent for, of course, Donald Trump. So all that is coming up in Florida. We got some stuff to unpack there. Before we turn our attention over to Georgia, and Fani is really in the deep of it, in the thick of it. She's really plundering down there. And she's got another thing she's got to deal with from Congress coming up, of course, with Jim Jordan and the Judiciary Committee. And they sent her a warning, Fani, big Fani alert. You are about to be held in contempt of Congress, because they've sent her multiple letters. We know how Congress is. They just sit around a lot of the time when they're not, wasting our time in the congressional chambers. They just type letters up. Hey, yeah, I order this. We are Congress. So they sent a bunch to Fani. She looked at them and threw them right in the shredder, along with all her receipts for her cash deposits and her Grey Goose purchases. But eventually, Congress gets a little tired of it. And so Jim Jordan has sent over a subpoena and is now threatening Fani to be held in contempt of Congress for violating the subpoena. So things are getting a little bit spicy there between Congress and big Fani Willis. We also came across this very interesting post from at GSU Grinding. This is a guy, I believe he's a law professor, and he wrote a very interesting thread about why Fani can't or won't refile those charges, the 6 charges that Judge McAfee dismissed that we covered in depth yesterday. And we were wondering, what's Fani going to do? And he's saying, look, Georgia's a little unique. They have it's not like other states. if she refiles this, it's really everything is going to go back to the deadlines of the new filing because there was no notice on those charges. So it doesn't really matter how this goes. She's probably not going to be wanting to refile this. So very interesting thread that we'll unpack. And then this guy, he filed a bar complaint. He's just an everyday taxpayer there in Georgia. And he said, I'm sick of Fani stealing our money and giving it to her boyfriend. And so we'll listen to a little bit of what he has to say. And then also late breaking news today was Alvin Bragg apparently is caving. Womp womp. Sorry, Alvin. So we have trial coming up, of course, at robertgovea.com/calendar. You can see all of the activity, all the cases we're following, all the show times are on there. But Alvin was scheduled for trial on the 25th to start with jury selection. Trump requested an adjournment, and turns out Alvin's kind of okay with a 30-day delay. Weird. So something strange happened. Apparently, he got a bunch of discovery that came from the DOJ. Very weird. A lot of people are mad at the DOJ. I think that they're probably working together in cahoots on this thing. I think Alvin Bragg has a case that's probably even worse than Fani's, if you can believe that. And so they're just stalling this thing because they don't really have much to go on. So we'll unpack this and we'll see what's inside. Apparently, the DOJ dumped like 73,000 pages of documents on Bragg. And he's like, we need more time to prepare. Like, very curious, very curious. So we'll hear from him. Andrew Weissmann is furious about this. He says, I'm livid, rah, rah, on his X account. And some other, people with big lefty accounts are also very unhappy about this. How dare Merrick Garland? Like they're rabid furious because this is all they care about. They want to convict Trump before the election. And if Alvin Bragg delays this, well, it might be the beginning of a snowball effect and it might just continue to be delayed. So Alvin has agreed to delay it. Whether the judge delays it, we'll see. And of course, it's going to be fun either way. So we got 3 good segments to get to, my friends. Of course, we are grateful that you are here and with us today. And we have a lot to unpack. And of course, before we do, we want to ensure that we are all healthy and fortified and nutrified. And one way to do that, Field of Greens, baby. Now, Field of Greens is the healthiest thing that I do every day. And I want you on this journey with me. It's literally 1 scoop a day. Tastes great. And they also have flavors now. So when you go and check out, you'll see a bunch of other stuff there. And it's completely improved my life because this is nutrition the way that nature intended. And why do I love Field of Greens? Very easy. Way more energy throughout the day, sleeping better throughout the night, healthier hair and skin, helps with digestion, helps settle the stomach, and just feeling better and healthier overall. And Field of Greens is radically different. Each organic fruit and vegetable was medically chosen to support heart and vital organ health. And I trust Field of Greens to keep me healthy. And I promise you're going to love this product. But if for any reason you don't, they'll give you a 100% money back guarantee. And on our channel, we got you 15% off your first order plus free rush shipping. Very easy to grab some. Go to fieldofgreens.com. Use promo code Robert so you can save. That's promo code Robert. Fieldofgreens.com. Fieldofgreens.com. Links are in the description below. And of course, the vegetables want to be eaten. You don't even have to feel bad about it. Just shove them down in there and you'll be healthier as a result. And this hair is not included with the promo code. Okay, that's extra. So we also have watcherlodge.com. We have an amazing event coming up on Saturday. Don't forget to check that out. It is free and the link is down in the description below. Any PDFs that we're about to go through, those are at robertgovea.com, along with our newsletter where you can sign up with your email address. And of course, our members-only community is available at watchingthewatchers.locals.com. We do shows in the morning and we do shows on Saturday. And we'd love to have you join us. All right, now, let's get to it. Judge Cannon considering major motions for Donald Trump in the classified documents case. One of those motions has already been denied. Trump wanted to dismiss this case based on the idea that Jack Smith's charges were unconstitutionally vague. We'll talk about that one. But there's another one that's very interesting that she still has to decide on, and it is regarding the Presidential Records Act. Whether or not Donald Trump can declare records personal, meaning they're outside of the scope of the federal government, and how to enforce that. And does this justify a dismissal of the entire indictment? And we're waiting for a ruling on this one. But even if Cannon comes back and dismisses this one, during the hearing today, when they were arguing and debating these motions, there was what seems to be a consensus that Judge Cannon was very upset about the selective enforcement, the selective prosecution, the malicious prosecution of the Biden DOJ. In other words, the discretionary enforcement of the Presidential Records Act has been applied differently to Trump. it's been prosecuted against him, but not prosecuted against other people. How come that is? And so Cannon is saying that there may be some problems here that she'll address at a later time, but we're going to go through both of these filings and see what happened in court today, because we're trying to get our bearings straight on what Judge Cannon is doing. And of course, Donald Trump was also out. He's commenting on the distinctions between his classified documents case and Joe Biden's classified documents case, one of which is being prosecuted, the other is not. So we've got stuff to attend to. Now, briefly, let's take a quick look at the motion that was denied. So recall here, previously on our channel, we read through Trump's motion to dismiss, saying that all these 32 counts were unconstitutionally vague. And Trump submitted his reply brief, and he made the same argument. So Jack Smith said, no, they're not unconstitutionally vague. He said, yeah, they are. And he said that these counts should be dismissed. So we need actual notice, and all of this stuff is too vague to provide us with the notice that we need. Therefore, the case should be dismissed. Now, there were oral arguments on this. Judge Cannon came out and denied it pretty quickly. And this was one of many different motions. And so we're expecting most of these to be dismissed, but you only need one. So here is what she wrote. She said, here's my order denying without prejudice, meaning Trump can come back here and file this again, saying this cause comes before the court. This is Trump's motion to dismiss, saying Jack Smith responded in opposition, and the court heard oral arguments on March 14th. That's today. Order came out immediately, saying, well, upon careful review of everything, Judge Cannon came out and said the motion is denied. Okay, so Trump loses, but it's without prejudice. Maybe Trump comes back. They say Trump seeks dismissal of counts 1 through 32 of the superseding indictment, that's Jack's indictment, on the ground that the statutory phrases, quote, unauthorized possession. Okay, what does this mean? Put it in quotes. Unauthorized possession. How do you define that? Complicated. Same thing. Relating to the national defense. How do you define that? Entitled to receive. Trump says these are all unconstitutionally vague as applied to the president. Okay, these statutes are for non-presidents. They're for the general public. So when the president has special presidential powers, how do you apply them to the president? And in that situation, they are vague. Trump said that violates my due process, and the rule of lenity means that you should interpret it in a way that doesn't lead to the prosecution. Now, although the motion, says Cannon, raises various arguments warranting serious consideration, the court ultimately determines, following lengthy oral argument, that resolution of the overall question presented depends too greatly on contested instructional questions about still fluctuating definitions of statutory terms or phrases as charged. Sounds like it's kind of vague to me. In other words, like, yeah, we're it's hard to analyze this because there's a lot that we still don't know yet, along with at least some disputed factual issues as raised in the motion. So it almost sounds like still fluctuating definitions seems like it's kind of vague. Like we don't know, we don't know. So it's either this or it's either that. So there are some vagaries, but it's not necessarily vague as of yet because we just haven't decided what the definition is. Now, once we decide what the definition is, then I can maybe decide if it's vague, but we're not clear on the definitions. So because we're not clear on the definitions, I can't say whether it's vague or not. Maybe once we settle on a definition, then I can tell you whether it's vague. And I know that sounds convoluted. It sounds even convoluted coming out of my mouth. But for that reason, rather than prematurely decide now whether the application of the law in these circumstances yields unsalvageable vagueness, because we don't have the definitions to measure whether they're vague or not, I can't decide whether they're vague. Despite the asserted judicial glosses, this court elects to deny the motion without prejudice, to be raised as appropriate in connection with jury instruction briefing or other appropriate motions. Okay, so it's not even a real denial. It's kind of like just bring it up later. So accordingly, it is hereby ordered and adjudged that Trump's motion to dismiss these counts is now denied without prejudice, done and ordered in Judge Cannon's court. So pretty quick one. We'll get through that one pretty quickly. Bring it up later. If you think it's unconstitutionally vague, let's let this case mature a bit so we can decide on what these definitions are. And then at that moment, we can say, well, yeah, that definition, government, is vague. And so now we can't come up with reasonable jury instructions when we're briefing these issues. And therefore, maybe we renew a motion to dismiss because you don't even know, state, what your argument is. All right, so judge denies that. Now, we were still in court on the day This is what it looked like as people were outside supporting Trump. He rolls in, and we're going to see what oral arguments look like on the other motion. This clip came over from our friend at Benny Johnson on the X platform. And here is what the reporting sounded like outside Florida.
Same time watching the former president arrive, and now we are again a couple weeks later. And what we remember from that day, Dana, is the number of supporters who were on that road as he arrived, and we expect a good number of people to be there too. They stayed the entire time that he was inside the courtroom.
Right. The other thing is that we're going to see a lot of this through this campaign season. The House Republicans invited President Trump to come to their retreat that's in West Virginia today. Of course, you could imagine he would want to be there, but he said, I have to be in court. So that's why he's there today.
This in light of the Robert Hur testimony from 2 days ago, where the Republicans proved that there were 7 different locations where Joe Biden kept classified material when he was out of the White House. In various places, the Biden Center, the Penn Center, a couple of different places in his house in Delaware, and on it goes. This is what Trump's team is going to argue, a similar matter when it comes to classified documents under the Presidential Records Act being held in Mar-a-Lago, Florida.
That's exactly right.
That's the argument they're going to put before the judge and trying to get some of these cases and charges dismissed.
And there's no cameras in the courtroom. We will provide you information throughout the day. It is expected to be a long hearing.
It went most of the day, and we're going to get into what happened. But as you heard there, they were talking a little bit about the discretion, right? Why was one set of facts, why was one president or vice president prosecuted or not prosecuted, but the other one was? And it's because of prosecutorial misconduct, which I think may be the exact issue that disposes of this case. We'll see. But the other one that has a lot of overlap with prosecutorial misconduct, with malicious prosecution, is what are they misapplying? What law are they perverting to apply leniency when they apply it to one person, but then to apply aggression when it goes to someone else? Well, the law is the Presidential Records Act. When Bill Clinton said those are personal records, no one batted an eye, right? Judicial Watch sued Judge Amy Totenberg, said, yeah, if he's the president, what am I supposed to do? Say that they're not personal records? He's the president. Take it up with the Constitution. We have separation of powers in this country and in our Constitution. And if you don't like it, Judicial Watch, get out of here. And guess what? They had to go. So how come now it's being reapplied differently to Donald Trump? Well, this was Donald Trump's final reply. So he sent this one back in before the oral arguments took place today in court in Florida. And here was what Trump's argument said before we see what happened in court and break it down. Arguments came in. Donald Trump says, all right, Judge, listen. President Trump here respectfully submits this reply saying that we need to dismiss the entire indictment because the Presidential Records Act tells us that we have the right to do this. The indictment must be dismissed first because Trump designated the documents in counts 1 through 32 as personal records. And Jack's office is foreclosed as a matter of law as saying that the retention of those records was unauthorized. DOJ, NARA, and even the Biden White House counsel have also taken similar positions. They have all historically argued that the PRA designations by former presidents and vice presidents are not reviewable in criminal proceedings. Asterisk, unless your name is Trump, but Trump. So the office's contrary position in these proceedings, now they just changed everything. DOJ, White House, and NARA, previously to Trump, they all said, you can't charge somebody for this. Now they have. Now Jack's office position, contrary to this, is meritless. And it's precluded by estoppel principles, meaning if you haven't pursued it in other cases, you can't just suddenly pursue it here. And second, because NARA, the National Archives, the head librarians of our whole country, who apparently are more powerful than the president, we learned. And because NARA's actions were politically motivated, thanks Deborah, and driven by the Biden administration as a political weapon against President Trump, NARA's February 2022 sham referral and its May 2022 rejection of President Trump's executive privilege claim violated the APA, the Administrative Procedure Act. And as to the referral, in light of the unbroken chain of custom and history of NARA inaction with respect to these record designations, in other words, NARA has never quibbled over how presidents declare their filings, their documents. These are personal, these are presidential. If they're presidential, they are presidential records. They go and they be archived, they go into the library. Got it. But if they're personal, like Bill Clinton's sock drawer tapes were. He gets to decide that, and he gets to keep them. No one's ever quibbled over that until Trump. Then NARA gets involved. They make DOJ referrals, and they pass this thing off to a illegal, unconstitutional special counsel who's illegally appointed. So there were not reasonable grounds to believe that there had been a violation of federal law. There was no precedent for this. No one could expect or have noticed that they would be charged for this. Now, therefore, the Non-Espionage Act, writes Trump's team, charges must be dismissed as well. So you can't hit him with this. They say, here's the deal. Judge Cannon, President Trump's designation of records as, quote, personal under the PRA by allegedly removing them from the White House while acting as president is not the product of alchemy. Okay, we're not smashing this together. Rather, this is the only fair inference from Jack Smith's allegation in the superseding indictment. They say President Trump caused boxes to be transported. So the president caused the thing to happen. And obviously that happened while he was still president. Jack Smith has even acknowledged that. So while he made this decision, he was president. He was exercising his presidential powers. And because you can't quibble with that decision, and there's no precedent of anybody quibbling with that decision, you're done. You can't suddenly say, that's illegal. They say this is also the same inference that DOJ, NARA, and a district court granted President Clinton in judicial watch. Similarly, in January 2023, a NARA official wrote to former presidents and vice presidents to inquire about materials previously assumed to be personal in nature. The office makes no effort to address the judicial estoppel implications of the DOJ's representations to the court in judicial watch or Crew versus Trump. So in other words, why should the DOJ be allowed to have two standards? If they pursued and defended the president in judicial watch or Crew versus Trump, they can't turn around now and say the opposite standard applies. Now they say, look, people will turn around and they'll say, President Trump returned those boxes because he knew that they were illegal and he didn't have lawful possession. And they say, no, that's not true. Get out of here. They say President Trump's subsequent decision to give those boxes back does not invalidate his earlier designation. They're still personal records. He just gave you those back. Now, by giving each president complete control over his personal papers, Congress hoped that it would encourage presidents to create and preserve such papers, and that presidents would later voluntarily donate those papers to the National Archives. Saying the superseding indictment, as they continue, Trump's team, it fails to state an offense. Nothing criminal happened here because the PRA, the Presidential Records Act, it authorized Trump to make and take possession of his records under his presidential authority. Now, the argument to the contrary by Jack proceeds by characterizing the law as a delegation of authority to the executive branch, saying the National Security Act was signed in 1947 prior to the enactment of the PRA. And then President Truman signed another executive order. And so thus, by the time Congress enacted the PRA in 1978, it was well aware of the authorities it was relying on. And Congress did not draw the distinction pressed by the office between the classified and unclassified records, saying the text of the National Security Act does not support the position of Jack's. The office admits that Congress exempted the president, from the scope of the regulations. Right, because the president is the root power. If Congress can define unless we have a constitutional amendment, if Congress can just pass a statute that can dictate what the president can or cannot do, Congress is the presidency. So all these whack jobs on cable news who say that, certain rules apply to the president that apply to every other officer in the world, not true, right? Because he is the enforcer. If somebody can pass a law like Congress by statute, not by an amendment that would actually modify the Constitution, then they can just usurp the presidency by statute. So Congress even admits that when they pass this stuff. They exempted literally the president from the scope of the regulations. But the office contends that the exemption is irrelevant because it doesn't apply to a former president. So what? The causing of the movement of the boxes and the delegation to the Presidential Record Act as personal happened at the time he was president. The assertion misapprehends that relevant time frame. Trump designated the records as personal under the PRA while he was still in office, not as a former president. At the time of the designation, he was expressly exempted from the provisions of the rules. For that reason, the 11th Circuit assertion in a different setting that executive order pertains equally to former presidents is of no consequence here. And furthermore, this other executive order does not override the PRA. Thus, the executive order addresses this, but the executive order makes no provision for records the president designates as personal. So he's allowed to maintain jurisdiction and custody over those. The suggestion by Jack's office that Trump's designations of the records is implausible does not stand to reason. Surely no one from the National Security Council or the intelligence community left individual documents in the Oval Office following briefing to Trump. The PRA gave discretion to the president to designate those records as personal. And NARA's responsibility under the PRA is expressly limited to those deemed presidential. So Deborah didn't have any jurisdiction over those personal records, and NARA did not assume responsibility for those records designated presidential until after Trump's first term. So none of these provisions distinguish between classified or unclassified records. So Jack Smith cannot escape the importance of these texts and these textual commitments. The rules give Trump authority. Trump also made his designations with the full force of his Article 2 authority. As the president that we talk about here, the opinion clause, the president has the right to the opinions of the leaders of his executive branch in writing. The Constitution says it. I think it's Article 2, Section 2, Clause 1, if I'm right. And it's right in there, right? And it's a powerful provision. So he gets that. Now, as a result, President Trump's designation of the records as personal, they failed to state an offense under this indictment. Therefore, these charges must be dismissed, saying there is no constitutional question for the court to avoid. It is in the opposition. They say the DOJ and NARA, the National Archives, they invoked the possibility of, quote, stark separation of powers problems in the Judicial Watch case versus Bill Clinton. In Judicial Watch, the concern was that judicial review of President Clinton's individual document designations would lead to an impermissible interbranch conflict. The argument was well-founded. Absolutely. It was actually a good argument. And it was by Judge Amy Totenberg. We read it here on our channel. The archivist, she said, the archivist also lacks the authority under the Presidential Records Act, the head librarian, to inspect the president's records or to survey the president's records management practices, because the archivist is not above the president. MSNBC? God. The court is left with the undeniable conclusion that Congress vested almost no authority in the archivist and NARA over vice presidential records during a vice president's term, right? Those are quotes from other cases. Crew versus Cheney. She's just a librarian, right? She doesn't get to make criminal referrals to the DOJ. But that's what they did with Trump. But they didn't do it with Clinton. In fact, when they tried to get Clinton's tapes, the judge said, I can't overrule the president. I'm a separate branch of government. It's his docs. It's his power. Leave him alone. Judicial Watch did. Now they want to reverse that. So as was the DOJ's contention to another federal judge in 2023, which Jack Smith's office does not even address, another case, they said, the DOJ said this, DC Circuit precedent provides that the court lacks jurisdiction to review day-to-day White House records management decisions under the Presidential Records Act. They say, wow, that's really convenient. So you submitted that in another case. Courts lack jurisdiction to review White House records. Weird. But then you prosecute Trump for those. So indeed, they write, indeed, yeah, Congress was keenly aware of the separation of powers concerns that were implicated by legislation that regulates the conduct of the president, because Congress can't do that until Trump. And they sought assiduously to minimize outside interference with the day-to-day operations of the president. Now, courts have no jurisdiction to review the president's day-to-day operation. That's Marbury versus Madison. If the courts can review the president, guess what? They're the president. And they're not. Neither is Congress, no matter how bad Liz Cheney wants it to be that way. The unreviewable day-to-day operations of the White House include, says Trump's defense, PRA designations by President Trump during his term in office. Obama did not suggest otherwise when he issued executive order decades after Congress enacted the PRA, because the definition of records in that order expressly does not reach personal records. And the court would not disrespect the executive order or the executive branch by interpreting the PRA according to its plain terms. Thus, the constitutional avoidance canon has no relevance here. They say Jack Smith also, they're trying to escape history. Deranged thugs won't even read the history book. We've got bad history for them. It's called the Judicial Watch case, which we've talked about. They say, hey, Judge Cannon, Jack Smith can't run from this. President Clinton's classified tapes, President Reagan's classified diaries, and recent positions taken by Biden's White House counsel all support Trump's motions. Jack does not dispute that President Clinton's tapes contained classified information. They say that's true. That much is clear. In Judicial Watch, in that case, a DOJ attorney represented to a federal judge that President Clinton, quote, presumably classified the tapes as personal records by not transferring them, right? Clinton, if he thought that they were presidential records, he would have transferred them into the head librarian at the time. He didn't. So by default, the presidential decision means they're personal records. That is what a prior judge decided. And it makes sense, because if the judge, or even if Clinton has to fill out a form, right? But before I fill out this form, I need to make sure, before you can take those records, Mr. President, please complete this form. What happens if I don't? Oh, well, you're going to be in violation of the law. For what? Access to my own documents? They're not yours. And you are not the president. And so your little form here is bureaucratic nonsense. It's not in the Constitution, and I don't have to follow it. So by not giving it back, that's the decision. Now, that contention alone should be extremely persuasive in this proceeding, obviously, involving attorneys representing the same government. The DOJ made the argument that Clinton could do that. They said by not moving it, they're his. By not transferring it back, they're his. He took them with him, didn't give them to the government, they're personal. Trump did literally the exact same thing. But President Trump's reliance on Judicial Watch is not limited to that part of the transcript. DOJ also contended in the Judicial Watch, when they were representing Clinton, that the PRA's administrative enforcement scheme is exclusive, right? So that if there's a problem with the documents, it's administratively dealt with, and argued that Congress would have to pass a new law, DOJ wrote this, to address any problems with presidents not properly designating records under the PRA. You can't charge a president under espionage. That's their prior rules. There is a bill pending in the House of Representatives that may accomplish some of these things, says Trump's defense, but the absence of such an enactment in January 2021 further supports Trump's position that the PRA applies without limitation to the records at issue in this case. And Jack Smith has failed to address the significance of 1791. So if Congress is now jamming a new bill through to close the hole, well, maybe they're exploiting an area of the law that was not clear. Trump did not have proper notice. It's a violation of his due process to prosecute him for something that he doesn't have awareness of is even a crime. Now, the court in Judicial Watch, Judge Amy Totenberg, agreed with the DOJ based on reasoning that is persuasive here. The PRA only authorizes NARA, Deborah in Trump's case, to take possession of records that were designated as presidential. Now, the designation decision is to be made by the executive. The president makes the decision, not Deborah. NARA lacks the mandatory or even discretionary authority to challenge those designations, and the PRA provides NARA with no role with respect to personal records. So Deb can't question Trump's decision, and when Trump makes it a personal record, that pulls it from her jurisdiction in the first place. Judicial Watch is the only case cited by either side involving document-specific PRA designations, as opposed to presidential agreements with NARA in tension with the PRA and the president's PRA policies and guidelines, which are subject to review in civil and administrative proceedings. There are other ways to deal with this. The DOJ and NARA, they did not question President Clinton's possession of tapes, and those tapes contained classified information. And it was inconceivable to all involved in Judicial Watch that there was any mechanism, much less a criminal mechanism, to recover them directly from a former president. Nobody thought it was even remotely possible to go arrest Bill and rummage through his sock drawer. Need a biohazard suit to do that. DOJ, NARA, and other agencies took the same approach with respect to Reagan's diaries. Reagan had a bunch of classified stuff in those diaries. But Jack Smith's office tries to seize on the reference to diaries as the definition of personal records. But that argument is inconsistent with the office's attempt to harmonize the law with the executive order. If executive order and its predecessors apply to classified information in personal records under the PRA, which would be inconsistent with the order's definition of records, then the order's predecessors apply to Reagan's diaries and Clinton's tapes to the same extent they apply to Trump's. So if you can't have it both ways. They apply or they don't. These are the real world facts, Jack. No one interpreted these authorities in that fashion until Trump announced he was running for re-election, and everything changed. Not even the Biden administration, says Trump. Specifically, the White House counsel's office and Mr. Biden's personal attorneys, they've also argued that the PRA authorizes a former president or vice president to keep classified materials in locations that are not approved for classified information at home, as long as those materials are not defined as presidential records under the PRA. That's from the Hur report. All right, so pre-Trump DOJ, pre-Trump NARA, pre-Trump Judge Amy Totenberg, pre-Trump, well, this is current Trump, but even current Joe Biden, all say president has exclusive control over the PRA, can declare what is personal or presidential, can make decisions just without even speaking, just by taking action, and that the remedy for any violations of this is through civil and administrative procedures. And how dare anybody even think about criminal charges for Reagan, for Clinton, and for the others? Now, this special counsel's office should not be able to suddenly do the different and prevail on the contrary position here, trying to incapacitate Biden's chief political rival and former president and Republican nominee for the president. It's official now. Congratulations to Trump. Now, they say NARA and their unlawful agency action, Deborah, sending this stuff over to the DOJ, it supports dismissal because this was inappropriate. The Non-Espionage Act counts in the superseding indictment, says Trump's defense, cannot stand here because they are based on unlawful agency action. NARA violated the law. Saying here's how that worked. Beginning in September 2021, NARA worked with the Biden administration on a politically motivated mission to investigate Trump by abusing the PRA. NARA's response to this political pressure renders the unlawful the agency's actions, including the sham referral in 2022 and the May 2022 purported waiver of Trump's executive privilege. They just waived it for him. Jack Smith's office cites this law, but it fails to respond to Trump's additional argument that the sham referral itself was unlawful. In light of NARA's customs and practices before all this, there were no reasonable grounds to believe that there had been a violation of the law. Trump's retention of personal records was not unauthorized under the law. Look at all the other presidents. Therefore, her referral was an improper agency action, violated the APA, and courts have dismissed charges that are based on unlawful agency action. And they say, finally, it's very easy, Judge Cannon, says Trump's defense, very straightforward to reconcile President Trump's position that a president's designations under the PRA of individual documents as personal cannot lead to the unauthorized possession of those documents. That's ridiculous. If he says they're personal, they're his. And that is supported by prior positions of the DOJ, NARA, and the White House counsel from Joe Biden themselves. They all know the exclusive nature of the civil recovery mechanism has been incorporated into the law. they've conceded in the prosecutorial misconduct opposition. They concede that NARA has no enforcement authority. So NARA referred it to the DOJ and they did it. They say agreements, policies, and guidelines relating to the PRA may be reviewable, but that must occur in civil proceedings, not criminal prosecutions, which is why they gave it to the DOJ, and Merrick Garland kicked it off to Jack Smith, who's illegally appointed. They say, in addition, Judge Cannon, to our knowledge, there has never been an effort to use a civil replevin action to collect presidential records from a former president, a return of property. Rather, all replevin actions for this purpose have been brought against third parties and presidential successors who never wielded authority under Article 2 or discretion to designate these as personal records, right? Like other presidents, other people who are not president. The absence of a criminal penalty in the PRA and the existence of an exclusive civil recovery mechanism that has not been applied to former presidents are both consistent with this motion. And such a lack of historical precedent is generally a telling indication of a severe constitutional problem with the asserted power here. Jack Smith's office expresses concerns that a former president might, quote, try to sell personal documents to the highest bidder. That is what President Clinton did by permitting Taylor Branch to write about tapes containing classified information. In response, the DOJ and NARA hardly lifted a finger. No one raided Bill Clinton's disgusting home. The special counsel's office should not be permitted to predicate an unlawful prosecution on a contrary interpretation of the PRA, and for the foregoing reasons, this superseding indictment must be dismissed. Respectfully submitted by Todd Blanche and Christopher Keese. Good motion, and I think, it's clear. There's a massive double standard that exists under the Presidential Records Act, but she may not bite on this one, right? She might want to save it for the selective and vindictive prosecution filing or order additional discovery, because this is the misapplication of this, right? This is the rule that was misapplied, but now we're talking about the people who did the misapplying, and that's in the vindictive and selective prosecution motion, which was unfortunately filed under seal, so we do not have that one to read. But let's take a look at what happened in the proceeding today. And we had a brief update here from the Epoch Times, who were there in the court building. They're inside the court building. And let's just see what some of this looked like as the day unfolded, scrolling back to the beginning in the morning, where there were some extremely problematic definitions that was happening. So we arrived, we're on scene there in Florida, bright and early in the morning. Former President Trump's motorcade pulled up to the Florida courthouse. Cheers of supporters chanting, Trump, Trump, Trump. As with most court appearances, it was a lively morning. Cannon enters the courtroom. All rise. Please be seated. She says, good morning, everybody. We're here to talk about the motions to dismiss. We're going to start today with the unconstitutional vagueness motion. Trump's attorney, Todd Blanche, says, Your Honor, good morning. These charges must be struck and dismissed. The judge asked some series of questions about whether this was premature. Mr. Blanche, isn't this a little premature? Seems like you might be talking about some stuff that exists outside the indictment. And Mr. Blanche said, well, Your Honor, I think it's appropriate here. Other cases have done that as well. And Mr. Blanche brought up what we just talked about. He said, by the way, Judge, Bill Clinton and Ronald Reagan and even Joe Biden, his situation, all of those situations are parallel to this current case. All of those presidents retained documents after their presidency, said Mr. Blanche, and the Department of Justice was complicit in that. They allowed them to take those documents, and they chose not to prosecute them. So it's unspeakable, says Trump's defense, that the DOJ is here today approving and even prosecuting this case. We know that Clinton's tapes were very serious, Your Honor. Clinton shared tapes containing military information with his biographer. Cannon said, well, do those contain classified information? Mr. Blanche said he didn't know. But we know because they referenced it in their motion. In their own motion, they said that did contain classified information. Cannon was still thinking through this. She says, I want to dive into this. What is the definition of unauthorized, Trump defense? What is unauthorized to you? Blanche said, I don't know, Judge. Judge, I don't have a response to that. I can't define that. I'm a defense attorney. Talk to them. Judge said, I'm a little frustrated about this because we're going to have to get it in jury instructions and everything. What I'm trying to get at, Mr. Blanche, says Judge Cannon, is who would be entitled to receive these classified documents? Who can get those? What is authorized? What is unauthorized? And Trump's defense said, well, Your Honor, there's an extremely problematic situation here, obviously. There's a lack of a legal definition. We got these weird terms like need to know when it comes to classified information. No one knows what they mean. It varies case by case because you might need to know, but you might not need to know, and who knows? So the judge said, Cannon, this indictment, by the way, I was looking at it, it alleges that it became a crime the day after Trump left office for him to have the documents, whether or not he designated them personal. Is that right? Trump's defense said, well, I want to distinguish this. Here's another parallel. Joe Biden retained classified documents, and the DOJ chose not to prosecute him because they didn't determine there was a crime. And so the retention issue should not be a crime in President Trump's case either, right? Being in simple possession apparently is not a problem. So that's alone not enough, right? The possession of the documents. Judge saying, interesting. Now in the motions, the attorneys say that count 19 should be struck. Cannon says, is there an official process to transition or to remove a president's clearance? Defense team said, no, there is no formal mechanism. It says if it happens at all, there's no real mechanism. So it's just kind of inconsistent, like they don't have an exit process for the presidency. Cannon says to the defense, would other officials run afoul of what the DOJ says is illegal in President Trump's case? Like if he got prosecuted for this, would other DOJ officials? He says, absolutely. Yeah, a bunch of people would if they held this standard, but they only hold the standard for him. Now, the judge says, okay, thank you, Mr. Blanche. Let's hear from the government. Jay Bratt stands up, this guy. He's up for the prosecution. He says, Your Honor, my name is Jay Bratt. He says, Your Honor, President Trump could not have designated the classified documents as personal records. They're classified. You don't get to classify classified records as personal documents. He said, Your Honor, by the way, I want to tell you about this recording. Trump made a recording after he left office. He referred to a stack of classified documents. He says, I could have declassified, but I hadn't. Bratt argued that this was his admission that the documents had not been designated as personal. And he said the Presidential Records Act anyways allows presidents to deem personal correspondence only, Your Honor, as personal, and official documents related to the government would by definition be presidential, right? So he wants a different definition of this. The president, according to our, broad interpretation, can just declare either way. I declare this is personal, presidential, doesn't matter, classified, whatever, it's mine, which I think is the ultimate interpretation of this. Like, again, if someone else can tell the president, oh, sorry, that's classified and you can't have that, I need to see where that authority comes from. Like, where is that authority? If someone can point me to something that overrides the president's, then okay, I'll believe that. But if it's a congressional statute, if it's U.S. code, or if it's some executive order from a former president or something like that, no, right? It's the president's discretion under the Constitution, Article 2. So it's much more broad. Like, I don't care what the rule says. The president only has access to personal correspondence. No, anyways. So he wants a much narrower definition to say that Trump is illegal. So Cannon says, well, I want to ask you about this timeline, Mr. Jay Bratt. How come the investigation, Jay, wasn't open the day after President Trump left office? Like, if this was so illegal and NARA is throwing themselves into such a hysterical fit over this, how come they didn't open the investigation the day after Trump left office? I mean, if that's the moment it became illegal, says Judge Cannon, then how come you didn't start investigating him then? Well, they said, President Trump, Mr. Bratt, he says, could have realized and returned the documents later, I guess. Well, the judge asked, was there an official person designated to receive those documents if he returned those documents? And Bratt said, even if President Trump had given the documents, to like his Republican friends in Congress, this case would have never been brought. I don't care where he got them, maybe a ballot drop box or something. It would not have been returned to the correct person but he would have sought to return them. He argued he could have sought to return them, even if he didn't know where to give them back. So the judge is like, was there like a library Dropbox? Like, since you have a head librarian, Nara, does she have a Dropbox that's convenient for him to drive through? He said no, but he could have figured it out. And Bratt said, security clearance isn't even specifically given to a president. So there's not like any clearance at any point. He said presidents instead get lawful access to classified information during their time in office. But this only allows them to view the information at work, and not to take them home and put them in his basement or garage or drawer or any one of Joe Biden's other 5 locations. Certainly, the judge said, seeming to side with the prosecutors on the idea that Mar-a-Lago was a residence and not, as Trump said, an authorized space for classified documents. Bratt said the lawful access ends when the presidency ends. And Cannon said, well, okay, Mr. Bratt, I want to address some cases concerning other presidents with you. How about these past presidents and these vice presidents? I mean, Mr. Bratt, you brought up other officials being prosecuted who have retained classified information before, but now I want to know, how come history would not then inform a sitting president of what was acceptable, right, Mr. Bratt? I mean, listen, if past presidents had been able to retain classified information and not be prosecuted for that, what would lead the next president to believe otherwise? If they didn't get prosecuted before, why me? She asked if this would not make it a case of arbitrary enforcement. Now, Mr. Bratt could not name an example. Can you tell me, Mr. Bratt, what would have given some other people some notice, this president notice that he could be in trouble if this happened? Bratt couldn't come up with an example. He said, by the way, Judge, Clinton's tapes did not contain classified information. We have a disagreement about that, clearly. Judge Cannon responded. He said, okay, that's okay. Cannon says, well, but Reagan's tapes, they had classified information, right? Didn't they? And nobody prosecuted him. And he said, yeah, that's true, but Reagan was the first president to do that after the Presidential Records Act was passed. And so, he didn't know any better. Then prosecutors continued and they pointed to statements. They said, by the way, Trump's different too, because Trump knew that his retention was illegal. And he made comments about Hillary Clinton, another person who didn't get prosecuted, and prosecution over retaining documents. Defense attorney said, Your Honor, this does not meet the fair notice standard. We can't know that he's going to be prosecuted if everybody else who ever touched a classified document or brought them home didn't get prosecuted. Why would Trump? So in a motion to dismiss for unconstitutional vagueness, the defense would have to show it's not clear what crime Trump is being prosecuted for. They said, okay, we got that. The defense and the judge seemed to disagree on how far they would need to go on being vague in order to strike down the statute. Trump's defense argued that a vague law was no law at all. You can't have a vague law, and that courts could not rewrite statutes to save them. And Cannon drew a line in that courts could certainly interpret the laws. A break happens, and we come back to discuss the Presidential Records Act, the one that still remains. Defense attorneys for Trump are up. They say, welcome back, Your Honor. Great to have, hope you had a nice lunch. They say, Your Honor, presidents since George Washington have taken things out of the White House, and the President Records Act allows for these records to be kept at home. Now, our position, says Trump's team, is that Congress, in passing the Presidential Records Act, gave presidents the discretion to choose, their discretion, what documents to return to the librarians at NARA and what should be kept for public keeps and what else they can take home. Now, the NARA is an archive. They're tasked with record keeping. They don't have any authority to tell a president what records are personal or what records are presidential. This discretion has always been the president's until Trump came here. Now, the defense continued, and they asked, does NARA really have the authority to designate records as personal or not? And if they do, if they can designate, they have that authority, the president doesn't, even though we said that they did in Clinton's case, we have a question. Why they waited so long to indict Trump and claimed the case was politically motivated, says Trump. We know why. Because it's motivated politically, because they had to lob this thing off in the middle of the election season. The defense arguments overlapped with another motion to dismiss, which is, of course, the selective and vindictive prosecution motion, which is saying Jack is misapplying the PRA. They argued, they said, the current administration even agrees with our position. The archive can only request return of the documents, but they have no authority to retrieve these documents. Ask Clinton, ask Reagan. Both NARA and the DOJ, they took the position that they had no say over the president's retention to those documents. And they said NARA has never, ever before made a criminal referral against a former president. And that Trump was never informed of a criminal referral, so he had no notice about this case at all. They said neither the DOJ nor NARA, Your Honor, have the authority to designate personal versus presidential. And we're not asking the court to decide either, because Trump has already done that. They added, if the court could review and designate records, then that would be you making the decision. The president makes the decision. NARA can't make the decision. Sorry, Judge, we love you, Judge Cannon, but you can't make the decision, and Congress can't make the decision either. Look at what NARA has done with past presidents, Judge Cannon. The archive sent a letter to George Bush after he left office. They said, George, do you have any classified information to return? The spokesperson said, no, we don't. Attorneys argued that NARA had operated on an honor system, and then when Trump came around, they indicted him. They said, by taking the documents, Your Honor, that's enough. Trump was designating those as personal records. Thank you for listening to our arguments. David Harbach jumps up for the prosecutors. Jay Bratt's probably tired. Took the position that the Presidential Records Act, he says, Your Honor, that's ridiculous, whatever they said. It doesn't give the president carte blanche to allow former presidents to mishandle classified documents. He says there was no record or evidence of Trump designating the records as personal. He didn't fill out our forms, and he never wrote it down, or he never told anyone, or he never marked the boxes as personal. This feels like a bunch of cope to me. He didn't put a label on it. He didn't use the label maker that we got him for Christmas. To which the judge responded, that was not a fair standard. No one could assume admission of guilt from that. Good Judge Cannon, yeah. Oh, he didn't use a piece of duct tape that says personal records on there? All right, now, what's your next point? Thanks. Judge Cannon asks them, I want to know whether the defense reading of the PRA made it so the statute superseded the Espionage Act. So does the PRA take precedent over the Espionage Act, the illegal law? Which one is first? Which makes it the unauthorized possession of the classified information illegal. The judge said, I need some case law. You know, it's difficult to see that it gets to a dismissal here based on the PRA. Government had argued that the defense interpretation that presidents could designate any records as personal effectively guts the PRA, which was intended to preserve presidential records for the public. And the defense Trump's team came back and said, that's not what we're arguing at all, losers. And that if the prosecutors are saying that the Espionage Act applies to personal records, then it would have to apply to the diaries as well, so long as it contained classified information, and in the cases of Clinton and Reagan. They argued if Congress really wanted to change that law, they can change it, but that's not how it stands now. And the prosecutors came out and they said, Your Honor, just for the record, I want to assert that we are not puppets of the Biden administration, okay? We're a special arm of the DOJ. Jay Bratt gets super offended, sensitive guy. So we're a special arm of the DOJ. They probably have business cards made up. I swear, I'm not joking. So, all right, Trump leaves, court's in recess. Judge Cannon said at the end of the hearing, she would rule on these two motions promptly. We've got a prompt ruling on the one, of course, that was denied. But there was pretty wide consensus on this today. Obviously, this is federal court, so we don't get to hear what happened inside. But Julie Kelly sure did. And she's an amazing journalist and reporter who was covering this all day today. And I'd encourage you to give her a follow. Here's what she said happened there in the courtroom. And she's here with a prediction. You should follow her at Julie_Kelly2 and sign up for her reporting. She says, from the Florida courthouse, I'm here with a prediction. Dun, dun, dun. Brace yourselves. Says the Robert Hur report and the testimony is the biggest elephant in the room in the hearing. The term arbitrary enforcement was used frequently by both the defense and Judge Cannon. Cannon hammered the fact that no former president or vice president has been charged under the Espionage Act for taking or keeping classified records, including national defense information. which represents 32 counts against Trump in Jack's indictment. Here's Julie's prediction. Cannon won't dismiss the case based on the motions debated today, either vagueness or protection under the Presidential Records Act, but it's very likely she will dismiss the case based on selective prosecution, a motion still pending before her. Whoa! And I've seen that echoed from other people who are on the opposite side of the aisle, said that Cannon seemed very perturbed about the selective prosecution. Obviously, it's ridiculous. Cannon pressed both the defense and special counsel to explain when the, quote, crime begins. She noted the date in Jack's indictment as when the Trump violated the Espionage Act was on January 20th, the day he left office. Jay Bratt confirmed the crime began that day, and he was entitled to retain the documents. Cannon again asked for historical precedent as to when a former president faced similar conduct. Bratt said, we don't have one. And said vice president on numerous occasions, right? Because people like Hillary, Joe Biden, Mike Pence, they all skated on criminal charges. Trump was the only one. Cannon said, quote, arbitrary enforcement, according to Julie Kelly, is featuring in this case. Whoa. Also addressed foreseeability. How can Trump foresee that he'll be charged with the crime if you can't define the criminal conduct? Trump could not be aware that he was committing a crime by keeping these materials. She said something like, given the constellation of what happened before, meaning no criminal prosecutions have happened, either of Bill or Ronald or vice presidents or Clinton, Cannon suggested Trump could have reasonably expected he was in the clear. Obviously, because many people were in the clear, and FBI twisted themselves into pretzels to excuse the conduct of Clinton. And so make sure you're following Julie Kelly, my friends, over on the X platform and supporting her work. She does great reporting, and she's there, boots on the ground inside. And so now let's listen to what Donald Trump says about all of these double standards. He was on with Greg Kelly and was being interviewed, asked questions about how he is persevering through all of these prosecutions. And here is Trump in reaction, in response to the multiple cases he's contending with.
Now look at where you are.
Well, I've watched people over the years, politicians get indicted, and the first thing they do is go to the microphone and say, I'll be leaving office now, and I will fight for my name and my reputation, and I'll be going back home to my family. You know, they leave for a lot of different reasons, but nobody's ever been hit like me. And there's never been anything like this. Look, my numbers are highest. Nobody's ever seen numbers like this. I believe that if this didn't happen, perhaps they miscalculated, and perhaps they haven't. Because don't forget, it's not over yet. But there is some kind of a protective force, because you look at what I've been hit with. These are horrible people. These are corrupt. You know, Jack Smith, I call him deranged Jack Smith. This guy is out to murder. Here's Joe Biden with 50 times the number of documents, classified stuff. He took it all for a 50-year period. And don't forget, they can blame his mental health. And I agree with them on his mental health. His mental health is terrible. But they can blame his mental health. But 20 years ago and 10 years ago and 30 years ago and 40 and 50 years ago, he didn't have, let's say, a mental health problem like they talk about today. So they release him from liability. And you're talking about many, many times the documents over many years, and he didn't have the Presidential Records Act.
He was not the president.
Which totally protects me, in my opinion, totally protects me. You know, I was dealing with them. We were dealing fine. We weren't. And then all of a sudden they raided this house. They raided Mar-a-Lago. These are corrupt people. But they release Biden. What Biden did, he wasn't protected by the presidential because he wasn't president. He took him when he was a senator. Dick Durbin got up and said, if he did that, that's a real bad thing. That's as bad as it gets. Dick Durbin's on their side. And I just remember when he heard about that, he took a lot of classified documents as a senator. Dick Durbin couldn't believe it. So when you look at it, there's something going on, because they're going after me viciously. Then all of a sudden it comes out that Biden took 10 times the number of documents that I did. And I took them very legally, and I wasn't hiding them. We had boxes on the front of and a lot of those boxes had clothing, and we're moving out, okay? Unfortunately, we're moving out of the White House. And because we're moving out of the White House, our country's going to hell. But we weren't hiding anything. He was. And then you see him in with his Corvette. Nobody ever mentions the one, though, that's the worst, is he had him in Chinatown. And those were boxes that were used. If you take a look at those boxes were, there was a lot of activity in those boxes. They show pictures of them. These were boxes that were used. In Mar-a-Lago, we had the Secret Service. We had all sorts of security. We had everything. And what he did was far more egregious. I mean, what I did, I had protection. I had the right to do it, in my opinion, and in my lawyer's opinion and everything else.
He did, absolutely. And we're going to see what Judge Cannon says about that. Of course, we're going to be covering this one, waiting on a ruling from her. The ruling came out pretty quickly on the void for vagueness. Of course, that was denied. And even if this Presidential Records Act motion to dismiss is denied, there's so much overlap between a lot of these same issues. I think the big one is going to be the motion to dismiss for selective and vindictive prosecution. That was filed under seal, so we have not read that yet. But according to many people, not only Julie Kelly, but many others, there is some serious problems in Judge Cannon's mind about how this case was brought, improperly being applied to Trump, others excused. Of course, that is exactly true and reality. So we're going to be here continuing to cover this, my friends. We'd love it if you subscribed and joined us and invited someone that you know to come over here during our live streams so that they can join us as we unpack the truth of what's happening in these cases. We also have some great links down in the description below. RobertGouveia.com is where you can sign up for our nightly newsletter and get access to the PDFs that we just went through. We also have WatcherLodge.com, amazing free events over there. Come and join us for our next Discover Your Purpose and Goals workshop. And of course, watchingthewatchers.locals.com, our members only community where we do live streams in the morning and on Saturdays. And we'd love to see you there. Thanks for joining us, my friends. And we'll see you back here on the next one. All right. We're not done yet, my friends. We're going to Georgia because it's Fani time. And Fani's catching it from another angle this time. Fani Willis, threatened by Congress with contempt. Jim Jordan on the Judiciary Committee has had enough of Fani's noise, right? She's been making a lot of hot air coming out and gas, and it's just enough already. Congress has sent a subpoena, and now he's threatening to hold her in contempt because she's not complying with the subpoena. And so Big Fani's in trouble. And we have a great report from this account on X saying that Fani's probably not going to be able to file those charges that got dismissed a second time, because that's going to delay the case basically indefinitely, which is adverse to their interest. And Fani also got hit with a bar complaint from this nice Georgia man who's tired of her taxpayer dollars going to Fani's boyfriend. And so let's see what Jim Jordan says right out of the gates. He says, Fani, enough of this garbage already. We're Congress. Who do you think you are? From the Committee on the Judiciary, Jim Jordan sends this one to Big Fani Willis. He says, all right, dear Miss Willis, guess what? The Committee on the Judiciary is continuing its oversight over your corrupt DA's office in Fulton County. And we have concerns about your receipt and your use of federal grant funds that came from the DOJ. On February 2nd of this year, Big Fani, after several attempts to obtain your voluntary compliance with our oversight, the committee sent you a subpoena, which we read through here. Now, the subpoena compelled the production of two specific categories of documents, Fani. One, documents and communications referring or relating to Fulton County's receipt and use of federal funds. Hopefully, Nathan Wade knows what a receipt is now. Maybe he can educate Fani about this because they had difficulty with that word back during the evidentiary hearing. And number two, Jim Jordan said we wanted documents and communications referring or relating to any allegations of the misuse of federal funds that came by your office. And we know that there's a whistleblower, okay, because Jim Jordan has confirmed that for us. He says there's a whistleblower that says there was actually misappropriation of funds. Now, on February 23rd, Fani, you responded to the committee's subpoena with a letter in which you smeared a former employee of yours who spoke out about your misuse of federal grant funds. We're not going to dignify your attacks on this brave whistleblower, Big Fani, and your continued attempts to distract from your own egregious conduct through misdirection and personal insults. You know, she's got a lot on her plate here dealing with her indictment of Nathan Wade. The allegations in the public realm about your misuse of federal grant funding are concerning, though, Fani, and the committee has an obligation to examine them. Jordan continues and says, we appreciate that you have produced a narrow set of documents in response to the subpoena, but your compliance with the subpoena to date is deficient. You haven't given us anything. Attached to your letter were various documents. I wonder if she put her calendar on there again. A number of which were previously produced to the committee that contained, among other things, 15 award letters from the DOJ's OJP and Office of Violence Against Women. What? Fani took all the stuff that she put on her refrigerator, that Nathan Wade put on her refrigerator, you know, with the magnets. Great job, honey. You got a Saving Women in America award. Yay, good job. You got a Justice for, Justice Against Bigots of America. Okay, great. Nice job, honey. Oh, you want another sticker? You want another star? Okay, here you go. So she apparently like faxed those over. 15 award letters. She's like, I'm doing a great job. The DOJ loser said so. From their justice programs. Got it. Oh gosh, these people are so pathetic. Now on and approximately 27 screenshots of expense budget summaries that were available. So I guess she's saying, like, I use this money to get awards or to launch these programs or something. So whatever. She slaps on a bunch of crap. She's like, it's just Congress. They're losers anyways. Sends it over to them. She's like, what are they going to do? Send me another letter? They did. Here's another one. So, however, you failed to produce any of the following categories of documents, says Jim Jordan. 1, all documents and communications referring or relating to any allegations of the misuse of those federal government monies. All documents or communications between you, among your office and the Justice Department, including its various components. All comms between your employees about the receipt of or use of federal government money. All documents that fall within the scope of the subpoena, including applications, proposals, grant agreements, financial management systems, internal controls, and other things. And all communications related to your office's grant performance. So when you get the money, and your progress reporting information. So Jim says, give it to all of us. Now, although additional materials are likely also responsive to the committee subpoena, as an accommodation, we will prioritize the production of the documents and the communications identified above. So forget about all the other stuff. Just get us that. Now, your letter also requests that the committee, that's us, you said you want us to, quote, engage with the Justice Department to obtain responsive documents that you should have. You told us to go to them, but you should have it. As part of our oversight, the committee has engaged with the DOJ about its administration of the federal grants. And the committee's separate request to the DOJ did not alleviate your legal obligation to comply with our subpoena. We're going to both sides. So in addition, Fani, in your letter, you noted a preliminary objection to our committee subpoena on the grounds that the subpoena is overbroad. And you said it's unduly burdensome. Now, to the contrary, okay, the committee has exercised its authority with restraint. The subpoena seeks only 2 categories of documents, and the scope of its request covers only a limited time period, namely from January 1, 2020 to the present. And in addition, we also prioritized the stuff that we wanted, so we're accommodating you nicely. Now, while, Fani, you have indicated that additional documents may be forthcoming in response to our subpoena, the committee has yet to receive any additional documents in the 3 weeks, Jim, since your initial response. And so accordingly, the committee expects, Fani, that you will produce all responsive documents to the subpoena in the categories prioritized by us no later than noon, March 28th, 2024, 12 p.m. If you fail to do so, the committee will consider taking further action, such as invocation of contempt of Congress proceedings. If you think that will happen, maybe. Who knows? Thank you for your attention to this matter. Sincerely, Jim Jordan, Chairman of the Judiciary Committee. You think Fani's going to respond by March 28th? She already got a subpoena. She flushed it down the toilet. You think she's going to respond? You think Congress is going to do anything about it? I don't think so. So we'll see what happens, but the threat is there, and maybe they will actually do something at some point in time. Not so sure that they will. But Fani is still in a bit of a predicament because this was an interesting X thread, and I wanted to plug this and shout out this gentleman at GSU Grinding. And apparently he's a criminal defense, tax law, con law, and litigation attorney, an adjunct professor, super collector, and he helps disabled vets and children. So shout out. So here is a great thread that he posted, and I wanted to share this. He says, look, here's a quick explainer on why redoing the dismiss counts. So remember, Fani lost 6 counts because she couldn't even properly plead anything because she's incompetent. Why this is not going to be an easy and quick fix. And I know there were some concerns on yesterday's show that maybe McAfee was dismissing these as like he was gifting something to the defense because we know that he's not going to disqualify Fani. And this may be something that is a little bit more consequential and not as easy to remedy as some other people were saying it might be yesterday. So he says, here's the deal. Unlike federal courts and apparently some other states, a superseding indictment or another indictment, a second indictment, where you stay on the same timeline isn't really a thing, right? So like you start the case. We all know we got speedy trial provisions and deadlines and all sorts of stuff. So can you issue a superseding indictment and just keep everything on the track, issue a second indictment? He says, well, you know, a clever prosecutor might argue in an appropriate case for an expedited timeline because the first indictment is really the same as the second indictment, right? They're kind of the same. But that doesn't really work in a situation where the basis of the granted demur, the granting of the dismissal, was a lack of adequate notice, right? The reason those 6 charges went away is because we didn't know about what they were claiming was criminal. So if you refile those, you have to restart that whole timeline, right? Because now you have proper notice. So you should get the same amount of time that you've got in the other case, essentially. So that leaves 2 options, right? 1, take the entire case back to the grand jury. And 2, indict the dismiss counts correctly in a second and separate indictment. Now, 1 isn't going to happen because if you dismissed everything, right? Like that's crazy. Like it restarts everything. The entire case would have to come back. You could do that in theory, but you wouldn't be back to trial for, he says 2027, maybe earlier than that, but maybe not. So option 2 is the only other option. The problem with option 2 is it reopens the ability to redo everything in that case. Right now you're arguing about fresh deadlines in case number 2. That evidence that you don't want McAfee to consider in disqualification on the first case might come back up in the second case. So fair game in a new motion to disqualify in case number 2, right? Like do it again. Strategically, that'd be very dumb. Additionally, because the acts in case 2 are acts in furtherance of the RICO, and now you run into a double jeopardy problem. So in my opinion, there's no reason to open up that can of worms for some of the counts. So a couple of other technical, jeopardy questions. If you have dozens of overt acts in the second case and in the first case, what if you're acquitted in case 1? Then are you also acquitted in case 2? It's actually a lot more complicated than it sounds. So it's a very interesting thing, right? Fani might be stuck on those charges. And so that might support our table theory where the judge is just knocking out the legs of the table that we talked about yesterday. So another possibility and a great, interesting post from GSU Grinding on the X platform. But we also have this gentleman. He is just an average IT gentleman from, not that there's anything average about IT. Shout out to all of our IT friends out there. You guys save everything. But in other words, he's not a lawyer, right? He's not somebody who's like an interested party in this case, just a citizen who's sick and tired of Fani and her lover grifting off of his money.
I was watching that.
Let's hear what he says about his take on this case.
News since January when all this broke, that a defense attorney found out that they were sleeping together, which she initially denied or didn't speak to. And then it came out that she did. And so I was watching that. I've watched a number of items there. I watched the Senate hearing, the Georgia Senate hearing that they had on the 6th of this month. And I voraciously read a number of things because it just didn't sit well with me, what I was hearing. I'm a taxpayer. My money was going to her boyfriend.
Yeah.
And then they were going on trips together. So all the taxpayers of Fulton were funding exotic trips on cruises and to Napa and all this, and money was going from taxpayers to him and then back to Fani Willis.
At issue, it's not just money. You also talk about truthfulness. You talk about misconduct. You talk about a lawyer as a public official constituting threat of harm to clients. We know that recent text reveal, it looks like they had been together for what your bar complaint says booty calls. I mean, that is metadata. As an IT technician, you understand that. That's been brought out. And also you cite in your bar complaint these comments that she made at a church, her first public.
Fanny calls in the House. So shout out to Georgia citizens who are holding their elected officials accountable. Shout out to that guy. It's, enough already. Like, it's your society. You want to live in a place where Fanny grifts 700 grand off to go on Napa Valley and cruise extravaganzas? No, we don't. And so we, my friends, are going to continue to cover this. We are patiently waiting for Judge McAfee's ruling. It's going to drop by tomorrow. He said it's going to be coming in hot. So thank you for subscribing and joining us as we continue to cover the Georgia RICO case and all of the rest of the Trump trials. We're covering everything here, and it's going to be busy as things start to heat up. So thanks for subscribing. Thanks for checking out some of the stuff down in the description below. Watch Your Lodge, members only community at Locals, and of course, robertgovea.com to grab the PDF if you want to read it. We'll see you back here on the next one. All right, my friends, and we got one more segment on the day until we hear from you. And this one, we're in New York. Alvin Bragg caves on that trial date. They were racing to get Trump tried and convicted in all the different jurisdictions throughout America. All the cases are a little bit off the rocker right now. Jack Smith's having a hard time. Fanny's in the thick of it. And so Bragg accelerated his case. Judge Juan said, hey, let's just set this for March 25th. But something happened today. Oh my goodness. Alvin Bragg submitted a motion and he said, you know what, Your Honor? We agree to a 30-day extension. What? That sent many people on the left into an absolute tizzy. They are very unhappy about this. And you can see one of those people is named Andrew Weissmann. We know who he is. He said when this news dropped that Alvin Bragg would be admitting or acknowledging and agreeing to a 30-day postponement, he says, what on God's green earth were the Southern District federal prosecutors thinking in turning this over so late? As we're going to see, there was a bunch of discovery that Alvin Bragg said he got from the feds. He says, if I'm the Manhattan DA himself, a former Southern District prosecutor, I'm livid. Right, they're furious because they wanted this trial to start, man. They wake up every day with like 19 days to the Trump trial, 18 days to the Trump trial, 17 days. Like, that's all they think about. So they get very perturbed when it is not on the docket. Now, someone else who is very upset about this is this gentleman whose name is Ron. This man named Ron. He said, it was a big error in judgment for me to defend Merrick Garland as long as I did. At every crucial moment, we learned that he has let us down because he is terrified to appear even minutely partisan. There has never been a greater instance in U.S. history of justice denied by delay. Wah, 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 wah. Right? They're very upset about this because they want trial to happen immediately. And so let's take a look at Alvin Bragg's filing. He says, Your Honor, we kind of agree with Trumpy Poo. Here's what he says. Defendant has moved for an adjournment or a dismissal, Trump has, based on claimed discovery violations, which are true. And Trump also seeks to adjourn the trial and the start of the trial by 90 days because the production since March 4th of approximately 73,000 pages of records by the U.S. Attorney's Office, which is a lot of pages. Now, these records were produced in response to Trump's subpoena to that office and also seeks to adjourn. Yeah. Now, the people's oppositions to the defendant's motion is currently due tomorrow on March 15th. So Alvin is saying Trump wants to postpone this. A bunch of documents came in. Now, the people's opposition will set out in detail our full compliance with Article 245 throughout the discovery process in this case. And we, says Alvin Bragg and his team, respectfully submitted by this guy, Matthew Colangelo, on behalf of New York, they say, we submit this notice in advance of that opposition to advise the court of additional developments yesterday, right? Trump wanted a continuance. This just dropped yesterday. Trial is scheduled for the 25th. After Trump filed his motion and the people submitted our one-page letter response, something happened. Specifically, yesterday, the U.S. Attorney's Office, the DOJ, they produced approximately 31,000 pages of additional records. Oh no! And they represented that there will be another production of documents by next week. Merrick Garland just dropped this all in their lap. So the government prosecutors from New York, they say, we just got hit with like a wheelbarrow full of boxes. And based on our initial review of yesterday's production, those records appear to contain materials related to the subject matter of this case. Including materials that Bragg requested from the U.S. Attorney's Office more than a year ago. And the U.S. Attorney previously declined to provide. That's weird, isn't it weird? If you buy any of this, to me it feels like this is just a little, good cop, bad cop routine. They're coming in. Alvin Bragg has the worst case of all time. His star witness is Michael Cohen, okay, who's a convicted liar, literally. So it's the DOJ just, I think, wanting to accelerate the case, maybe putting speed bumps on it. Why else would they do this? They want to put speed bumps on it, and Bragg is probably happy about it. These developments do not affect the people's compliance with all obligations under Article 245, meaning we're complying with discovery, and it certainly does not warrant a dismissal, and the people are ready for trial on March 25th. So this is not new. This is not prejudicial to the defense. Like the idea, that you drop in 30,000 pages plus maybe another 30,000 pages, who knows? The defense would be screaming foul. How dare you? On the verge of trial, you hit us with all this new discovery. We need 6 months at least for 31,000 pages, not 30 days. How about 12 months? Nonetheless, in light of the distinctive circumstances described below, and who knows what happened, Merrick Garland just dropped it all. The people do not oppose, this is Bragg, do not oppose a brief adjournment of up to 30 days to permit sufficient time for the defense to review the productions. Yeah, right, 30 days. For 70,000 pages of documents. Now, regarding the 73,000 pages of records produced by the U.S. attorneys as of the date of Trump's motion, Bragg's initial review indicated that those materials were largely irrelevant to the subject matter of this case, but there is an exception. Apparently, there's 172 pages of witness statements that Trump would have adequate time to review and address before trial. Yeah, but that's nice. Like, you say that they're irrelevant, Alvin. No one trusts you, government. No one trusts you. Maybe Judge Juan Merchan does, but they're irrelevant to you. The defense needs to look at every single square inch, every single dot per inch on that 73,000 page briefing bin of documents, every single inch. And it's going to take time to do that. Yesterday afternoon, however, Merrick Garland's DOJ, they dumped in another 31,000 pages of additional records to both Bragg and to the defense in response to Trump's subpoena. And they also indicated that an additional production would be followed by next week. So Trump can't go to trial on that now. We note that the timing of the current production of additional materials from the DOJ is a function of Trump's own delay. Alvin Bragg diligently sought the full grand jury record related to Cohen's campaign finance violations and his convictions from the U.S. Attorney's Office last year, and they wanted exculpatory material. They wanted the grand jury minutes remember, Cohen got convicted of perjury. So Bragg's like, I better see what his record looks like since he's our star witness. So they wanted all this material from the DOJ, witness list, other documents, basically like the case file, documents identifying the names and identities of grand jury witnesses, any grand jury subpoenas, documents returned pursuant to those subpoenas, exhibits presented to the grand jury, right? All of the stuff, like that's a lot of stuff, summary of witness interviews, search warrant affidavits, other evidence seized, and whatever. Okay, they want the Cohen case file, the whole Manila, the whole thing. Now, despite having access to those materials since June, defendant raised no concerns to Bragg about the sufficiency of our efforts to get those materials from the DOJ before last week. Instead, they waited until January 18th to subpoena those materials from the DOJ, and then they consented to repeated extensions of the deadline for their determination. Well, they don't have to go by your clock, Bragg. The timing of the attorney's office productions is a result of Trump's delay despite Bragg's diligence. I don't think so. They don't have to go on a specific time clock. Now, nonetheless, Bragg says, so it's Trump's fault, blah, blah, blah. But, okay, but what? Nonetheless, and although the people are prepared to proceed on March 25th, no, you're not. We do not oppose an adjournment in an abundance of caution and to ensure that the defense has sufficient time to review the new materials. We therefore notify the court that we do not oppose a brief adjournment, not to exceed 30 days, notwithstanding Bragg's compliance with all of our other discovery obligations. Their case is crap, okay? He knows it. DOJ knows it. Everyone knows it. It's based on Michael Cohen. We also request an extension from Friday, March 15th to Monday, March 18th to file our full response on their discovery motion in order to permit us to fully address any intervening developments since the defendant's motion. Judge Juan Merchan is going to be very upset about this, very unhappy that this is now going to be delayed, and the government is even agreeing. We submit this notice before filing our opposition of the defendant's motion to make the court aware of yesterday's developments as promptly as possible, and we're available for a conference with the court if the court requests. Whoa! So, not what they wanted, right? You can see why Weissmann and Ron are so upset about this, because the New York criminal trial is unlikely now, it sounds like, to go on March 25th, just a short time from now. So we'll see what the judge does and says. The judge could tell them, no, you're ready. You have enough evidence. Let's go. But if both sides are requesting an adjournment and they've got some good arguments as to why they need one because they just got hit with, 62,000 pages of documents, give or take, they're going to have really no choice but to postpone this. And a little bit of a postponement often triggers a whole snowball effect. Right now, Trump's going to say, what are all these documents that we just got? Where did this come? Who's this witness in here? We learned about this, and now appeal this and motion to dismiss, and it's going to open up just a whole new can of worms. They are delaying it. I think they know their case is terrible. And the only thing that would be worse than not having a trial, just to be clear about this, would be Trump winning a trial. Wouldn't that be much worse? I think that if Trump wins, they are totally screwed. They'd rather have Fani disqualified than Trump win, or Bragg delay the case than Trump win. And maybe there's something in that disclosure that seriously implicates Michael Cohen. Why else is the DOJ dropping 60,000 pages of materials over 2 weeks, about 10 days before trial starts? Because they're trying to slow roll this thing. Things got heated a little bit too quickly. And now Bragg is being saved by slowly, this good cop, bad cop routine. I want to go to trial. I'm ready to go to trial, but I can't. The trials are supposed to be, the process is the pain, and they need convictions. And something must be problematic with their underlying case, which is why they're delaying it. And they're trying to figure that out and manufacture the evidence to get that done. So another good day, good news for the Trump defense. They did not want to go to trial on March 25th. They're not going to trial probably on March 25th because Alvin Bragg Caves agrees to a 30-day trial delay. And of course, we're going to be here continuing to cover this trial and all the others. And we're going to update our calendar. We have all of the trials scheduled on our calendar at robertgovea.com/calendar. Links are in the description below. We had this one scheduled for the 25th to start for 6 weeks. But if it gets moved, we'll update the calendar. And if you add it to your calendar, you'll have all the show times on there and you'll know what court hearings are happening when. We had Judge Cannon on there today, and you can be apprised of all the Trump stuff, including deadlines, SCOTUS oral arguments, all that stuff. RobertGovea.com. You can also get the PDFs that we read there, sign up for our newsletter there, grab something from the merch store there, and of course, sign up on our locals by clicking one of those locals links and joining us on our members only streams. And we'll look forward to seeing you there and back here on the next one. All right, my friends. That is it for us on the day. And we covered some good ground. Bragg caves and agrees to a 30-day trial delay. It might turn out to be much more than that. Fani gets threatened by contempt of Congress from Jim Jordan. We'll see if they do anything about it. And Judge Cannon is now considering a dismissal of Jack's arbitrary prosecution. And it sounds like it's going to be something that might come out from the selective and the vindictive prosecution motion to dismiss, which of course we are going to be covering here. And now it's time to hear from you and to see what you have to say about all of this. Of course, we're going to take your questions, and I'm very grateful for your support. I appreciate all that you do to help keep this show on the air. And as soon as we're done, we're going to go over to watchingthewatchers.locals.com for our members only after party. And today we're starting right here. Thank you for that, Donut. Who's joining us? Dave H. What's up, Dave? Is our newest supporter on the YouTubes. Welcome aboard, Dave, and shout out to the Broncos. AG's in the house. What's up, AG? Also joining as a supporter. Great to have you. Paul M. says, are you planning on covering the Lindell, Kerry Lake, Arizona SCOTUS case to be filed later today? So I wasn't originally, but I've had several people mention it. So I'll take a look at it, and I wasn't really honestly sure what was even happening, whether it was Lindell appealing directly to SCOTUS or whether this was an appeal of some other case that is working its way up to SCOTUS. But when it breaks, I'm sure I'll see it. I'll take a look at it. And if there's good stuff to dig into, we'll cover it. Not a commie. Joining us as a supporter on the YouTubes. Welcome aboard. Mark Duke is also joining as a supporter. Welcome aboard, Mark Duke in the house. Doxson says, hey, Rob, did you ever cover Governor Kemp out of Georgia signing into law a bill that would open the doors to go after prosecutors like big Fanny Pack Willis? Yeah, we did. We covered a little bit of it yesterday. Just a little bit of a blurb. Actually, and we covered it before then too. We actually read through the bill itself some time ago. Yeah, so that was yesterday on the show. That was one of the things that might happen, like one of the possibilities that might, if Fanny stayed on the case, that might be a remedy to remove her. Glocky's in the house. Says, even though the DOJ won't do a dang thing, I guess the Republicans get a good job sticker for trying. The House may refer J6 committee members for prosecution. They should be prosecuted. Liz Cheney conducted a fraud on America. What's up, Alia B? What's up, Alia B? Welcome aboard as our newest shout-out member. And Glocky's here. Says Governor Sarah Huckabee Sanders is going to be Trump's Veep, but I'm horrible at political predictions. I think she'd be solid, actually. I think she'd be quite solid. Glocky says, from Bragg to Smith to Fani to the judges in New York and D.C., I'm beginning to think that the DAs and federal prosecutors in the DOJ do nothing but bluster and hype themselves to the point that most people think they have to take a plea when in reality, they are horrible at prosecuting cases. Well, I think they're horrible at prosecuting like new and novel cases where they have to think and be creative and step outside of the box, and like there's a strong defense and a political, response. They're very good at just the bread and butter cases like, DUIs, discons, domestic violence, those things. But yeah, like Fani, that was all just a facade. Same with Alvin Bragg. They get lifted up. There's this hagiography that's written about them, like the saviors of America. And it's just fake, just like everything else that we see from our government. Pritchie says Biden's a clown, DOJ's a clown, Trump and co. equals straight G's in the House. Holla. Lover of Green is here. Says, why are there still people in the Fauci cult? Good question. Are there? There are. You're right, there are. I still see them with the masks on. It's 2024 and a small percentage of Americans still do it. Never mind the fact that the world has moved on from that nonsense. It's bizarre. Yeah, well, there's that one. What's her name? What's her name? Taylor Lorenz. Yeah. look at her. She's a modern example of someone who really needs some help. Hey, it's the Munkets. What's up, Tony? Hey, Munkets. Bringing in some serious membos. We got 20 new membos coming in. Thank you, Tony. Who's here? Janine S. Squatch Girl. Good to see you, Squatch Girl. James P. Ian Brown's coming in. We got Bud S. ADR. We got Zach Guy. For Shizzle. John O. LMC. Blocks is here. James B. Rusty Banks. We got Lisa E. The End. Jim G. The Old Bag. LTC Vet. Mr. Twister. And Muffin Rando. All got gifted membos, courtesy of our friend Tony Hay. It's the Munkets. Thank you, Tony. Very generous. And welcome aboard to our new membos. Wild Things Forever says, how come Judge Chutkin says without prejudice? Is that to show that she's not biased? This is Judge Cannon today. If that's not said, what would that mean? Trump can't try again. Yeah, dismissals without prejudice means you can refile or retry. So like if your case is dismissed without prejudice, a prosecutor can charge you again. If it's dismissed with prejudice, it means you're done. You don't have any other options and you can't refile that. So with that same court. Waldo, what's up, Waldo? Bringing in new membos. Sweet Tat, thank you, Waldo. Tia T, television shows, Aging Cynic, and Rich all got gifted membos, courtesy of our friend Waldo. Wild Things Forever says, then why didn't she say with prejudice? Because she would seem biased? Yeah, it's not quite exactly like that. Like she's prejudiced against MAGA. I'm dismissing this with prejudice because you're a Republican. It's not that. It's legal prejudice, which means that it kind of, concludes the case. Like there's something, it's a hard word to describe, but it's a conclusion of the case by the court. Dolphin Fan is the man. Oh my goodness. Look at this. Dolphin Fan is the man, is bringing in 30 membos. Oh my goodness. Look who's back, my friends. Tupac Shakur's in the house. That's why we ride for life. West Side for life, baby. Steven 1872. Sparky. Florence W. Colin S. Woody Harrelson is here. Hey is here. Albert W. Andrea P. Drew D. No Mandates, who's not a Fed, is here. Jeff M. We got Rebecca J. Marjorie W. True American. Simon C's here. Timmy W. Heavy G, Darlene A, David W, Jacob A, Patrick R, Christine, Deb S, Isaac S, Isaac Space Jesus, Jennifer G, Patriot Will, Ulsterman, Warren Assange, and Melanie H, courtesy of Dolphin Fam is the man, bringing in 30 new membos. Dolphin, thanks for doing that, my man, and welcome aboard to our newest of membos. What is this? Knox Bierman, a defense attorney in Texas, shared this link. Apparently this link says, Kristi Noem is sued over a viral endorsement of Sugarland Dentist. Interesting article. Thanks, Knox. Hopefully you're having a beautiful day there in Texas. Pinochet's Helicopter Tours says on Rumble, it's unnerving when people say, quote, our democracy. I'm reminded that democracy killed Socrates because under a true democracy, even the slimmest of majority can force the minority to drink their poison. Yep, Alexis de Tocqueville talked about that, called it the tyranny of the majority in his book called Democracy in America. And I think he was a French kind of historian or journalist kind of a guy who came over and visited America. And he said, we have a serious danger of tyranny of the majority. Cowboy Rob says, Rob, what's your professional opinion of the Fani judge? As it stands right now, I think I'm hopeful that he does the right thing and disqualifies her. And I think he is, from what I've gathered, he seems like a very fair judge who cares about the decorum in his courtroom and seems like a guy of integrity. And I'm hopeful that his decision aligns with that perception that I have. Tony Hay says, I don't think it takes a lawyer to know that these trials are crazy. You're right. It doesn't. Yeah, it's not. These are not that. The craziness is evident, facially. We have here that these trials are crazy, but thank you, Robert, for confirming that they are crazy. It saves my sanity a bit. Your channel and your chat gives me a place to vent. Well, that's part of what we do here. It's like therapy, We all get to come here and navigate these waters together. It's a lot crazier if you're alone. You're like, because you want to talk to somebody and be like, can you believe this? And there's like nobody there. You're like, oh. So we get to go through it together. I think we have some fun. We get a little bit of knowledge through it, and we do get to vent and go through the shared experience together. And Tony, thanks for being a part of it and for bringing other people in to be a part of it. Grateful for you. We got David. Says, is there any way Trump can get his money back for having to defend these ridiculous charges? I would say it's going to be that's a tough battle, right? That's a tough one to win because these prosecutors are going to have immunity, qualified immunity. They're going to say that they had a reasonable basis to bring the charges. Trump's going to have to get over that hurdle and file separate claims. Like in the Fani case, maybe or like in the Florida case, if he wins like a selective or vindictive prosecution motion, maybe something like that. But it's tough. Those are tough. Those are tough things to win. Hey, what's up? Nitty Lenny says, I'd go to law school if Rob could narrate my textbooks. Thanks for making legal motions clear for us. Well, thank you, Nitty Lenny. I have fun. Sometimes I get a little into it, trying to get into the readings. I get a little carried away, but thank you, Nitty. I have fun doing it. And there's a lot more ahead. So thanks for being here and supporting us. Glocky says, no one can assume guilt by Trump not labeling his boxes personal. Would be a death blow to the prosecution if this case goes to trial, and that's part of the jury instructions from Judge Cannon. No one can assume guilt by Trump not labeling his boxes personal. Gonna need more than that. V is never silent says, this reading makes court exciting in real time. True crime buffs like me would eat this stuff up. These arguments with the law versus bumbling lawyers. What were your favorites watching The Watcher, folks? There was some good stuff today. Which segment was your favorite? Good to see you, V. We got this from Viva Maga says, where does Big Fanny keep her cash on vacation? In her fanny pack, but from Viva Maga. Chubby Stubby says, sounds like Fanny was looking for a gold star sticker from Congress. Don't know why else she'd be flippant and send those award certificates to them. Yeah, she's like holding them up. Like, I am a real DA, I actually have some certificates. Like, look how credentialed I am. Like, no, you're not. You're dumb. Nuh-uh, look. Look at this one. And look at this one. And look at this one. Yeah, but you just lost your bond hearing for Harrison Floyd, your revocation hearing. Nuh-uh, I'm good. I got this award. Okay, Fanny, take your awards and just go sit there with your juice box. We'll see you at 3 o'clock. Chubby is here. Good to see you. John McGarvey's mentioning this one. Oh, my friends, thank you, John, for throwing this one in here. This Saturday from 1:30 Eastern to 3:30 Eastern. And if you're on the Pacific Coast, that's 10:30 to 12:30. Yeah, Pacific time. Discover Your Purpose and Goals workshop with my mama, Marianne Govea. She's amazing. She's got a lot of experience helping people figure this stuff out. WatcherLodge.com. Come and join us. It's going to be a live stream, and we'd love it if you participated. We'd love it if you took some notes down and came up to the stage and shared what you're working on. That way we can all learn from our own input. So come and join us. WatcherLodge.com. Right there on the calendar. It's free. Starts this weekend on Saturday. Love to see you. Hey, it's Pi Day, right? 3.1415197. No, that's not right. Maryam is here. Says Megyn Kelly and Alan Dershowitz spoke today, and they don't think that the judge is going to get rid of Fanny. They think maybe Wade will get the kick, but not Fanny. They have reasons, and they sound pretty good, unfortunately. Yikes. Maybe I'll have to listen to that one. I hope not. That judge got lied to big time in his own courtroom. That would be very disappointing if that happens, but they might be right. Both very smart people. Spud says 8675309. Good to see you, Spuds. Lady Ice says Navarro lost his appeal, needs to report to prison by March 19th. It's an outrage. He's 74 and these are BS charges. Can't he appeal to the Supreme Court? Probably. I think, what did he get rejected from? From the DC Circuit? Yeah, but I don't know that they'll do anything about it by the time he has to report. It's terrible. What's happening to Peter Navarro? The dude is an American hero, right? He's been serving this country for a long time. And he's got caught up in Liz Cheney's fake propaganda committee hearing and rejected them. And now they're going to imprison him. We're going through a strange time, right? When you look back on like the downfall of the Soviet Union, you say, what was happening then? Elections were being rigged. Opposition parties were being thrown in custody. And they still say that about Putin. But we're doing it here in our own country. Wild times. Husky Mom, pray for Peter. Pray for Peter Navarro and his family. Husky Mom says, wait a sec. Why do they need so long to go through those documents? Trump wasn't afforded extra time to 8 Washington monuments full of documents. No, he wasn't. You're right. Jack Smith just said, or Chutkin said, you should have been reading those before you got indicted. Pinochet says, is the DOJ tanking these cases to temper retribution? I think they have a terrible case, and I don't know why they dropped all those documents in, other than to stonewall it. I mean, look, even if, other than to slow it down. Yeah, we got this one from Viva Maga, says, attention watchers, just want to point out that our fellow watcher, Dan Sundin, is representing us well. I noticed Dan in the chat on another very large stream from the lead attorney, shout out, who's typically the most super chatted creator in the USA. Whoa. Perfectly explaining to the uninformed masses the bro versus pro doctrine. Well done, Dan. Hat tip. Shout out to Dan. Yeah, it's a good doctrine, and it's exactly, I think, a good way to explain this in, simple terms. So shout out to Dan. Dan, thanks for getting out there and spreading the good news about what we talk about here. We got Let's Go Brandon. Hey, we got a baby in a month. Table for baby plus 1 month, please, from Let's Go Brandon in the house. We got a baby and then some. And congratulations, Brandon. Thanks for being here, man, for 10 months. Newest baby in the house. And 1 month. And, actually, I don't know really anything about babies. I can't talk too much about it, but we got another one. Thank you, Brandon, for being here. Roy MC says, is it possible that the DC prosecutors and judges are finally realizing that Trump will soon be president again and they're starting to distance themselves? Yeah, I don't know. I think that they still have all their eggs in this basket. Like, this train has left the station. I think that it's going to continue to go. I don't know that they can put this one back in the bottle. Hey, Flash says, Rob, it seems that all the cases against Trump fit into William Butler Yeats' poem, The Second Coming, which contains the line, things fall apart, the center cannot hold. Good comment there, Flash. Neurodivergent says, hey, Rob, when did you say SCOTUS would rule on Trump's immunity case? I can't wait for them to blow up all these cases. So, good question. I don't know when that would be, but oral arguments are not even until, I think, when was that? April 25th? So we have some time. Yeah, we have some time. Is it April 25th? Yeah, I think it's in April. So, we have some time. We got this one from Jennifer. Says, excellent show today, Rob. Thank you, Jennifer. Very kind of you. Hope you and the watchers and the fam have a great Thursday. It's a beautiful Thursday. Tomorrow is Friday, and we're excited about that too. Good to see you, Jennifer. Hey, what's up, Chetty Mo? Is a new supporter. Good to have you, Chetty. We got World War Wit. Says, I doubt U.S. Code 241, 242 will be a cure. What about 42 U.S. Code 1985 or 1983? Good questions there from World War Wit with some U.S. Code citations. Merms is here. Says, bringing in 5 new membos. What's up, Merms? MJ23 Goat. Carol C. Warchild is here. Muad Deeb and M. Kaz all coming in courtesy of the Merms. And John McGarvey says, hi, Rob, if Trump wins, will he get his boxes of documents back? Yeah, I would argue he should, right? That's his evidence. Yeah, it's not illegal. They're his documents. He declared them to be personal. They illegally absconded with them, and he should get that evidence returned back to him. That would be my argument. Case should be dismissed. And if it's dismissed on prosecutorial or malicious misconduct, I would like to see him, sue for damages for the prosecution in the first place. But is he going to win on that? That's a different question. What's up, Chris S. Says, just found your channel. If, quote, take a load off Fani doesn't get the boot, I will be very disappointed with this judge that appears to be on the level. I agree. I will be disappointed too. And I can easily see him doing it, right? Like, I can easily see him deferring to the bar, deferring to the jury, deferring to the voters, right? All that stuff. I hope I'm wrong about that, but I could see it. I hope he does the right thing, because he seems like somebody who cares about that. I might be wrong. But okay, so he might be getting pressure from the White House. We have no idea, right? In the court of public opinion and in the court of law. We also don't really know what he's seen, what else he's seen. There was a lot of stuff there that was under seal and that he did in camera with Terrence Bradley. which might mean that he might be more inclined to disqualify. But who knows? Let's see what's up on X, my friends, and see who's joining us over on the X platform. We got some good comments in the house. And let's see who is joining us on the day. Over on X, at Rob Govea ESQ, James P. says, what if Fani makes a deal with Congress for immunity if she rats out the White House? Yeah, that's a nice theory. I don't think that's going to happen. Paul Minot says, raise your hand if you have no case. You got these four prosecutors, all doing it. Hey, Thomas Murphy's running for Senate. Thomas Murphy for U.S. Senate. Sounds like a good candidate. We got Captain Salty says, in the House, your package is at the post office. Whoa! Okay, I got to make it over there. Says the new 20 ounce I did last night turned out sweet. The 40 ounces were testers. I'm going to have to run a new 40 ounce one with the settings I use for 20 ounce. Thanks for what you do. Love the shows. Okay, my friends. So I'm going to go get some new tumblers from our friend Captain Salty. He's the owner at freedomgear.org, right? Freedomgear.org. He's making some new tumblers. And apparently you're in Arizona. That's pretty cool. So we'll check that out, and we'll of course bring those back and share those on the show. Hey, what's up, Donkey Mama? Says, Rob, you're the best. I don't need TV news anymore. Just watching you now. Well, thank you, Donkey Mama. That's a huge compliment. We try to, actually talk about real things here. So I appreciate that. I'm glad that you're here. Feline Fun says, Fani's submissions to Congress were just smoke and mirrors in an effort to divert their attention. Her deception is telling. Salty says, need a fact check on this. I just heard this was Trump dancing on Soul Train. I don't know about that. And Always says, so it's conceded that it takes 30 days to review 30 to 70,000 pages of documents. So what would the timeline, would it be linear if there was 11 million? Yeah, good comment. And Sheila says, NARA has also changed the way they archive Trump's orders, right, versus anyone else's. Biden's been able to take credit for things that Trump did. I don't have the ability to research it, but someone else certainly should. So good stuff, my friends. Thanks for joining us and following us over on X at Rob Govea ESQ, and for following other watchers out there in the wild on the X platform. We are grateful for everyone who is out there engaging. We also had some other donos. This one came from Lady Ice. Says Navarro lost in the federal appeals court, DC panel 3 judges. In light of all the corruption, you would think a subpoena from them would have no authority. Cowboy Rob says, I hope he gets the documents back and the government's made to apologize. That would be nice. And we want Jack Smith to wear a dunce cap and sit in the corner for 10 years. Merms says, thank you again, Rob. Thank you, Merms. Very generous. Very nice of you. Good night to all. It's getting late here and I still got to work tomorrow. You're over there in the UK. So it's late. Is it still +5 or is it +4 now from the East Coast? Maybe it's +4 now. Yeah, it's getting late. Merms, thanks again for your charity today, for your donos, and have a beautiful night's rest. We got Crash says, Thomas Murphy on Locals. You saw him on X. He is FMF Doc here on Locals on the platform. And so very, very generous, my friends. Thank you for sending those in. And thank you to John and the rest of the crew, Donut, for clipping for us today. That, my friends, is going to be it for us. We are going over to watchingthewatchers.locals.com for our members only after party. We'd love to see you over there. One more reminder, we got all of our PDFs and show notes and our newsletter and our merch store available at robertgovea.com. You can check that out. Watcherlodge.com is where we have our goals and purpose workshop this Saturday. It's free. Type in watcherlodge.com or click the link in the description below. Come hang out with me and Mama Govea. Don't forget to eat your greens, fieldofgreens.com. Don't forget to use code Robert when you check out. But that, my friends, is it for us. Fred Pedamonte says, guys, Johnny just whispered to me, Epstein's alive. I knew it! Fred, your life might be in danger. Be careful with your rascally dog. We got this one also coming in from Sandy. Says, the best way to head off a reasonable belief of civil unrest occurring at the RNC convention over SCOTUS rulings is dismissing cases is to formally nominate Trump from Mar-a-Lago beforehand. So maybe there'll be another new summer of love, courtesy of the Democrats, coming in soon. Sure hope not. All right, thank you, Sandy, for that one. And Roy MC says, here it's midnight in the UK. Shout out to our friends in the UK. All right, my friends. Well, that is it for us on the day. Before we go over to watchingthewatchers.locals.com, where we do morning streams and Saturday shows, we want to thank the mods and the meme smiths who keep things nice and beautiful and orderly around here, including the Antikas Prime, K-Bean, we got Just Cause, Playin' Hooky, Ronnie Cole, Zulu, Beyond Geo, Zach Nichols, John Allen, Janek, Dog Digger, and Donut Mind Me. And of course, thank you to John McGarvey for helping to clip out and keep this show on the road today. We also want to thank our meme smiths, Geegum Geegum, Sleepy Dog Lee, and Nathan N810. But that, my friends, is it for us on the day. I want to thank you for joining us. I hope you had a beautiful Thursday. Tomorrow's going to be an amazing Friday. And we're going to be back to get into it tomorrow. And we need to see you right back here so that together, with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful night, my friends. Sleep very well. See you right back here tomorrow. Bye-bye.